Welcome to The Law Matters, and of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program's been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources that'll help you decide whether or not you might actually want to handle some issues yourself. If you do need outside professional counsel, you'll be better prepared, and as a result, so will the professionals you select. Our goal, of course, is to have you be prepared. Hope you will save time, money, and achieve better results. The Bazar and Associates law firm in East Providence continues to donate their time, their experience, and their insights on the various topics that we tackle every week. We want to thank them and welcome Attorney David Bazar.
Thank you.
Okay, so today, prom season, summertime, parties, they're all upon us, and so are the attending legal problems. So today we will discuss the common prom problems and the promposals, such as they are. Time for you to know your rights and some of the wrongs. This means for you parents too, who might decide that you'd like to host those pre or post prom parties, or maybe graduation parties or summer parties. So we'll revisit some of the social hosting laws that we've spoken about before, and if time permits, we'll also tackle what could be a very large topic, that being what to do with divorced parents and summer visitation and kids going to camp. But first, let's get started with what is a hot topic. In view of First Amendment, which we often discuss, so the hot button question is, every year people want to bring someone to the prom. It had always been the opposite sex, but certainly not so now. What are the laws? There's an LGBT hot button. What's the law these days?
So, given all of the changes we've gone through in society to this point in time, you would think for the most part that there are no restrictions on who you want to take to the prom, and that whoever it is that you think is an appropriate person to bring, you could bring. Of course, that doesn't always play out in every school, in every state, in every city. And what can a private school, for example, require? What can a Catholic school, for example, require? What can any public school require? So, for example, if you wanted to bring a convicted felon as your date, and that felon is convicted of some sex crime or something like that, I would think that even a public school can say, no, that person is not going to be able to come to the prom with you. It's reasonable, it's safety, and that comes first. Whereas, what is the right of a girl at an all-girls Catholic school, perhaps, to say, I want to bring a girl as my date to the prom? Can the school stop her from doing that? And you do get into certain rights and issues, and it's very interesting. There was a case one time, so let's just talk about what's within the school's realm and what's not. And this was a case that involved St. Ray's in Pawtucket, where they required a young man to cut his hair. And he sued. And the issue was, did they have the right to do that? And the Supreme Court held that it's a private school, it's not a public school, that they have certain rules and requirements for you to attend, and it's part of a contractual arrangement that you have with the school, and within the school handbook and requirements of what they can do, that is something that they could require. Does that now extend to, I want to bring a girl to a date with me at Bayview or some other all-girls school if they have a prom? And now I think you're starting to really go on a very interesting debate, which is the private school's right to determine who can come to a prom, and the individual's right to make their own choices. And given where society is going, I would suggest that I think that the court might lean towards the person's right to make that decision versus the school's.
Shouldn't there always be non-discrimination? I mean, there are rules,
right,
but non-discrimination.
Right. So I guess it's okay to discriminate against long hair if you're a private school, and I agree that that can be their rule. They can require dress code. And this is the same argument that would go into the decision. If you can require a dress code and say that you have to wear a shirt, a jacket and tie, or whatever it might be, you can require a certain kind of haircut. That's part of that. That doesn't really discriminate against anybody's rights. But when you start saying, well, no, you can't bring a girl, we don't recognize that, we don't allow that, even though it's a Catholic school, perhaps in that situation, can you force that on the school? And I think you're correct. The answer is yes, because the right of the individual against discrimination outweighs the school's right to determine who you can associate with.
Obviously, the ACLU has been heavily involved and very active, saying just flatly, the student should be able to bring the date or the partner of choice, freedom of expression, First Amendment, end of case.
You would think, and in some cases it absolutely will be. A public school, clearly there's not going to be any reason for them to be able to discriminate against somebody on that basis. Most private schools. The real closer call would be where there's a religious, now you're talking about the right to, freedom of religion and those types of choices versus the individual choices. And again, that's why I do think that under those circumstances, the discrimination part will push it over the edge towards being able to take whoever you want to take.
What about the idea that long before there was an issue about the opposite sex, the schools, public schools, for example, were pretty clear in saying that you get to invite the date of your choice. However, the student couldn't have been one who was either suspended or expelled.
Right.
Is that a discrimination? Is
No,
that discriminatory?
I don't think that's discrimination at all. I think that's much closer to the safety issue that we talked about at the beginning. It's if someone doesn't have a right to be on school property or at a school function because they've been suspended or expelled, then the school has a right to keep them away. And that will trump if it's a situation where they could claim discrimination because it's a girl who wants to bring a girl or a boy who wants to bring a boy. It's not being discriminated on the basis of, well, that's a boy and you can't bring a boy with you as your date. It's purely on the basis of, no, that child has been suspended or expelled from the school and doesn't have a right to be here.
For a cause, right. In the case of a prom or a dance or whatever, that's something that is not, that is a privilege, right?
Yes,
and that
it's
gives
not a
you
right necessarily, it's a privilege, and it goes right along with all the other rules of a school. You can't trample the rights and rules of the school by trying to create a false discrimination charge.
And while I want to pick up on a couple of those other related to issues related to what you have a right to do, how about the simple fact that things have changed and some kids want to go to proms? They don't have a date, they don't have a boyfriend or girlfriend, whether it was of same or opposite sex, but they want to go with a friend, with a bunch of other friends who are paired up as friends. And it's not even a matter of a same-sex date. It really isn't a date, just that they decided to share the cost of a pair of tickets or something. Can that be a valid reason to say, yes, I'm a girl, I should be able to take a girl, we're just friends?
You should be able to take a girl, whether it's a date or a friend. And I don't think that the school really should have any right to interfere with the choice that you make on that basis, as long as it doesn't create any other issues, such as we talked about the safety or risk of other students.
Okay. And in terms of school and school rules, what about when the student decides that she wants to wear the tux and he wants to wear the dress? How about choice of dress or inappropriate dress or any other kind of dress? What about dress codes?
So dress codes we talked about a little bit already, and I do believe that the dress code that we talked about with the private school would be different perhaps than a dress code required by a public school. Although there are some charter schools I think that have started putting dress codes in place and things of that nature. And it becomes a very interesting dynamic because now you can get into First Amendment rights and
Yes.
Can I wear a t-shirt to school that expresses a sentiment? No, we're not talking about the prom right now,
Okay.
but just wearing a t-shirt to school. Perhaps you can. But what if the t-shirt says, I want to blow up the school or let's blow up this place or something like that? That becomes a little incendiary or some other threats
Yes,
could
literally.
be made, or it could be something that infringes on other people's rights by being a hate type of statement or slogan. So can the school ban those things? Yes, I think they can. Can they stop me as the girl from wearing a tuxedo to a prom, or me as the boy wearing a dress? Yeah, I don't, if it's a true expression of self-identity, I don't know that the school will be able to stop that.
Good to know. What about it's the dress, but it's just too revealing? Private schools have more latitude to say, I think we'll put a T-shirt under that or something.
Right, I think that falls under the rule about the St. Ray's case, where yes, we can require you to cut your hair, yes, we can require you to wear a jacket and tie or school uniform or something of that nature.
Okay, what about conduct at that prom, whether two boys, two girls? Popular now is something called twerking. Well, if not twerking, the lambada, and depending on your choice of dance styles, could be a little bit provocative. What's the ACLU or First Amendment ruling on that?
Are you asking, for instance, if I could twerk at a dance?
Could you?
No, because I can't twerk.
No fear, David.
Right.
But legally, could you,
But
if you were
legally,
able to?
It's a form of expression.
Yes.
It reminds me a little bit of some of those movies, like Footloose or dancing movies where they want to have rock and roll at a dance or whatever.
Heaven forbid.
Correct. So there's probably limitations on what you can do at a dance within the bounds of reasonableness, but
Who arbitrates taste?
Yeah, well, that's the question. So can you have a pole with a striptease act at it and that type of thing? I think clearly no. Twerking, not 100% sure exactly what it is, but if it's a form of provocative dance, I think that's closer to being allowable. But it reminds me also, going back to the 50s in the movies, about the school master walking around with a ruler or something saying, you know, you can't dance that close and that type of thing.
Yes.
Times change, rules change. There is some latitude with what you can do, but there are some restrictions as well.
You would hope that the parents or somebody who is wiser and has a little more common sense, they might say, why don't you tone that down for this particular affair? So before we talk about social hosting laws, what about the conduct in school? Does the school have the right to suggest that you should take a breathalyzer test right here and right now?
Yeah,
can they force it?
Certainly a private school can. Can a public school do that? I would think so, because they can argue safety and that type of thing. You might argue you don't have a right without probable cause to ask me to do that kind of thing, and you're acting as a government agency, but they're not a police, policeman or woman trying to enforce a random drug test or alcohol breathalyzer. It's not a checkpoint kind of stop. So if there's advance notice, I would think that in order to get into the prom, we're going to be testing people, and it may be random, it may not be. Definitely a private school can do that. Can a public school do that? Probably a closer call, but I would think, since it's not a criminal check, but arguably a safety check, that they could do something like that. Okay,
and if you happen to be representing the student or the parents, and you've had a conversation in advance, if the child had been drinking and now is subjected to that invitation to have the breathalyzer, would you advise that boy or girl leave the party now before they take the breathalyzer, or?
Sure, I would. You open yourself up to all sorts of issues and things and violations, and I like proms that happen after graduation, because all the issues that happen at proms that happen before graduations can impact your ability to graduate if you're a senior and all of those things. So obviously my first thing would be make good decisions and don't do stupid things like drink before a prom or at a prom. But all that being said, if you're putting yourself in a dangerous or bad situation and you can get yourself out of it by just leaving and going home and doing the right thing, then do that.
Okay, let's get into the idea of the kind parents who decide that they'll host a pre-prom party, but it ends up being a pre-prom cocktail party.
Right. So
Don't go there is the first thing you're going to say, right?
Absolutely. And you know, there have been all sorts of these situations over the years. And there are two different issues. There's the criminal issue, and then there's the civil liability issue. Civil liability, obviously, is if you allow someone to drink at your home, that's the social host rule. Can you be legally responsible for any injuries to them or that they might cause? And it's different with adults hosting parties for adults than it would be with adults hosting parties for minors. But certainly the criminal issue is what's at play in hosting a pre or post prom party with alcohol for the children. And a lot of adults would take the position, well, back in the day, this is what we did, and we're going to be safe, we're taking everybody's keys and all of those precautions, but that's not going to relieve you of liability. If somebody is drinking at your house as a minor and there's a lot of noise perhaps, and the neighbor calls and saying, you know, it's 2 o'clock in the morning, there's a lot of noise going on there, the police come and they find children drinking on your property or in your home. And on your property or in your home is a change that happened, as you may recall, several years ago, when in Rhode Island at least there was a loophole in the law that said you had to be in the house rather than on the property.
So the parents aren't there and they aren't hosting the party, but the kids have a party and there is alcohol and there is an incident. Somebody gets into an automobile accident afterwards. Address the third-party issue. Give us a couple of examples of...
Well, you were talking about that back to the social host liability law. So if it was a party with adults and an adult drank at your party and got into an accident afterwards in Rhode Island, certainly the status of the case law right now is there's no civil liability for serving alcohol at a party. The adult is responsible for the action of the adult. There is case law in Rhode Island about minors being served alcohol and recklessly perhaps being served alcohol, and then something happening where, in one case, as I recall it, a minor hit another child at the party with a baseball bat, and there was some liability imposed because of the adults who were serving the alcohol knowing or should have knowing that that could directly cause the accident or situation to happen that did happen. It's less clear as to what would happen on civil liability if a minor was served alcohol, left, and had an accident. However, I would think that the direction that the case law is going in is there's going to be some civil liability eventually for doing that, if not now.
We've had some issues in recent years of parents' homes being the site of a party, and there being some trouble, and the kid is arrested. And we'd like to know what happens. We don't always get to know what's happening, but we know we shouldn't be doing it. Give us a couple of examples of that, because it certainly has been an issue.
I think the most famous situation, perhaps, or most infamous in Rhode Island would be the former governor's son having a party. And now at that point in time, the governor's son was 18. So he was the social host of the party.
Yes.
The governor didn't know, as I recall the situation, that there was a party going on the property.
He hadn't hosted it.
He didn't host it. It wasn't his main residence, perhaps, and he wasn't there. And even if he was, it was a big piece of property, so probably may not have known what was going on. But that was an interesting issue, and it pits the First Amendment of the media, the Providence Journal in that case, right to know, the public's right to know, versus the individual's right to privacy. And so it involves the records request, the access to access to Public Records Act, and in some places the open records rules. But whatever you would call it, the court has to decide and weigh and balance the public's right to know, the press's right to that information, and the individual's right to privacy. And in this particular case, the Superior Court judge said that the private rights, the individual's rights, outweighed the public's right to know. Given the circumstances of the case, the Supreme Court upheld that.
Yes.
And in upholding that, what the Supreme Court did, which was a little bit of a reversal of how many other states interpret this law, is they said that the requesting agency, in this case the Providence Journal, has to show that there's some issue going on, that the government did something wrong or there's some wrongdoing on somebody's part, that would outweigh the individual's right to privacy.
Yes.
And so they said the journal didn't show that in this case. I'm not sure that that is the correct standard. I don't disagree that the Supreme Court may have had very valid reasons, given all of the circumstances, not to release the records, but the reasoning, it seems a little flawed to me in saying that the requesting agency has to prove that there's something going on or some wrongdoing before they even get the records that might show that. It doesn't make a lot of sense.
If you had to defend a young person who was in that position, would you try to keep the media from publishing the whole story, whether it involved parents who were notorious or famous or anything of such?
Yeah, I do agree that it's really a conundrum in some ways, because there's a very important privacy right to be protected. And in that particular case, with what happened and what didn't happen, and the fact that the court, at least in looking at the records, felt that everybody did their job and did it correctly. And he was just 18 and just turned 18. In the record, he pled to a crime and that was expunged. And so to start opening that all up for no reason doesn't make a lot of sense. But that's not what the basis for the decision was. So I don't necessarily, like I said, I don't necessarily disagree with the decision in that case, just the reasoning behind it. Now, as you go forward, it's a case-by-case test, because it's a balancing test. It's balancing the journal, in that case, or the media's right to know, and the public's right to know, versus the individual's privacy rights. So if this were a case, and we'll just change the facts about, make it another state, a congressman having illicit affairs with prostitutes or something, and there's an investigation and all of that, and it's then covered up, the information's not released, no charges are brought, that situation, I think, is a lot different than an 18-year-old who had a bunch of friends over and served some alcohol to them.
Yes. Let's talk about this briefly from the student's perspective. Not all 18-year-olds live at home. Sometimes they're going to their own events because after they've left home, or maybe even they've lived in a college dorm. So kids have had questions about this, and maybe you could be their attorney, sort of. Kid is in a dorm room, and how liable are they for social hosting issues if they're in a dorm room and they may be, in one case, of age and in another case not? How does that play out, and how does it affect them?
Yeah, so that's a good question. It's interesting. And of course, every state, wherever the college is, may have different rules. So if you're having a party in Rhode Island in your dorm and you're 18, or your fraternity or sorority, and you're serving alcohol to minors, there could be liability for that. And you'd have to look at the wording of the statute versus what you're doing. And if you are hosting a party on your premises, and if the statute reads, and I haven't looked at the statute directly later, I don't know if it necessarily says landowner or inhabitor of the land. So if it doesn't say that, if it doesn't say that, it's where you live, your property, even that you don't own it, then you could rent an apartment and never be liable. So I do believe the statute, although I haven't read it lately, does provide for the occupier, so to speak, of the land to also be responsible. And if that's the case, then if you're renting the dorm room from the college in Rhode Island and you host this party, then you're going to be responsible for serving alcohol to a minor.
And a close corollary to that, so in dorms there are roommates. If the roommate hosts a party, you're not even there, can you be liable? Now, you're not there in one way, you might say probably not, but what about that civil liability that you talk about? Is that likely to apply?
Yeah, not really.
Okay.
And I would say because it requires, especially on the civil liability, negligence. And in order for there to be negligence, you have to know or should have known. And if you didn't know because you weren't there and you were home for the weekend and had no idea that this was going on, you probably should have known, but you won't pass that test. So in order to violate a duty to someone, which is required in negligence, you have to have the duty. In order to have the duty, you have to have some responsibility, which you wouldn't have if you weren't there and didn't know and had no reason to know.
So would you be advising that other student who knows his roommate is party hardy, loves to party, would you suggest to that teetotaler, for example, or not, since you know that your roommate is often likely to party on the weekend, why don't you get out of town? Why don't you leave the dorm? Why don't you go elsewhere? Would you advise that just because it removes his potential culpability?
Well,
or not?
Certainly as a potential culpability, yes. But if he doesn't want to go, he should ask the roommate to go somewhere else.
If he wants to host the party, that's part of the problem, right?
Right.
What about if you host a party in another state? Now, you said different states have different laws, and I'm not asking you to define every state here, but what law applies? The state that you have the party in, or the state that where you hail from?
It's where the action takes place.
Okay.
So if you're a Minnesota resident, but in school in Rhode Island and you're hosting the party in Rhode Island law is going to apply. If you're in Massachusetts, Mass law is going to apply.
Okay. You're at college, you're an adult, you are of age, you're hosting a party, you know who you want to be serving liquor to because you know that they're 21. Are you supposed to be asking your friends and your friends' guests, let me see your ID? What do you do?
You could certainly do that. Back in the day when I was in college and I belonged to a fraternity, drinking age was 18. Almost everyone in college was 18.
Yeah.
So when we had a party at the fraternity, we wouldn't even think of asking those questions. But if I were running the social life of that fraternity today and we're having a party, I think it would be fair to say, show us your ID when you come in, and have bracelets or something that say, yep, 18 or over, or 21 now,
21 and over.
Or not, and reduce your liability by having done something of that nature.
Good to know. And in the brief amount of time we have left, you referred to fraternities, sororities earlier. So they often host parties, weekends or whatever. Are you, as a member of that fraternity or sorority, liable even if you weren't actually imbibing when you shouldn't have? If your sorority hosts the party, your fraternity, are you liable? How does that work?
Excuse me. Potentially. If you're an officer of the sorority or the fraternity and you have some responsibility for developing what rules are going to take place and all of that, then potentially. But certainly, usually you would have to have some direct knowledge.
Good to know. Thank you. We certainly covered quite a few topics. We hope that that increases your awareness of what to do when you are hosting or attending parties and proms. We hope that you have a safe and happy spring season, summer season, holiday party season. We hope you will stay tuned to The Law Matters. We'll see you next time. Stay tuned because the law matters to you.